that this is a hearing today on a motion to modify the parenting time. And as a result of that, I'm advised by counsel that their first witness will be the minor child involved. So we're going to take a recess, step over to the jury room, and have that heard out in chambers rather than on the record. So, is there a court reporter?
No.
Right. The counsel for the parties and the court will be the only ones that will be permitted. We'll stand a recess. All right, we're back on the Forte.
All right, folks, buckle up because this custody hearing goes from routine to jaw-dropping in minutes. We've got conflicting testimonies, a minor child as the first witness, and emotional stakes that skyrocket fast. Keep an eye on how the judge handles that. It sets the tone for everything that follow.
Versus Forte case, and Ms. Brady, you are the moving party on this motion, so you want to put on any other proof?
No, Your Honor.
No. Petitioner has waived or rested their proof. So, Mr. Tully, you wish to offer any proof?
Your Honor, I'm for to have a motion. And that would be because even though the court, as the court knows, has broad latitude to modify these temporary parenting plans in this particular situation, I don't think that that's warranted. Testimony was heard from the child wherein she indicated mom feeds her, takes care of her, roof over her head. Now she has a little more rules than father does sometimes, but I don't think that rises to the level of modifying this plan here. And we understand that temporary plans are temporary, but oftentimes these types of plans roll downhill to where a permanent parenting plan might end up being. We don't think it's in the best interest of the child for her to be away from her siblings at this frequency, even though she may not think so. She's 15. Further, we understand that one of the best interest factors is that the reasonable inclinations of what the child might want over a certain age. However, from what I heard back there, I don't think that any of that was reasonable. Mother has a right to see her child, whether or not the child necessarily wants to or not. I just simply don't believe that there's any actual fear regarding any of the situations that she talked about. And I think it's in the best interest of the child for her to stay with her siblings and keep the week on, week off visitation as it is. She said to herself that father said specifically that he doesn't care if she goes or not. And I think that goes to the effort or lack thereof that father's making to actually cultivate the relationship with that child and mother in a loving way, Your Honor. So I'd ask that this motion be denied.
Mr. Brady, you wish to respond?
Yes, Your Honor. As to Mr. Talley's point that there would be reduced sibling time, this child testified that from October 2024 to August 2025, she was on an every other weekend, if even that, schedule with the mother as it was, and that it's only been this school year that the mother has began to enforce the alternating week schedule with her. So the reduced sibling time is not a critical thing. And also you heard the child testify that if she wants to reach out to her siblings, she'll just call them on the phone. Fear is not required. This would be a best interest analysis. If we want to move on into the best interest analysis, we can do that. The child testified the father repeatedly said she wants her to have a relationship with her mother. The problem is the mother, as you heard from the child, is on the phone with the person that threatened to kill this child. And that then is a problem for this child, and she doesn't want to be exposed to that. Even though this court has put down an order that she should not have to be exposed to that, she is exposed to that. And that's the testimony of the child. And also she mentioned the sleep schedule, which is a less concerning issue, but it is still an issue that should be taken into account from the court.
Looking at the evidence on a motion to dismiss, which is taking it in the strongest light, I find that there is evidence to support the motion. Whether that is or is not going to be granted is still yet to be determined, but for this stage, I deny your motion to dismiss. You may put on any proof if you wish, or we may move to argument on the.
And there it is. The judge sends everyone to chambers. Anytime a child testifies privately, it means the court is protecting the kid from emotional pressure. But it also means the adults now have to argue based on what they think the child said. Watch how both attorneys start spinning the story after this recess.
On the actual motion.
Thank you, Your Honor. I call Ms. Forte.
Forte, if you'll come around to our witness stand, please. I'm going to have you step up here.
Be careful with the chair.
You will raise your right hand and be placed under oath.
You speak up for them, Dad. You break down shit and how to so that, yes, sir.
Thank you. Just have a seat.
Could you state your name for the record, please?
Elizabeth Forte?
And you're the mother of McKaylee, correct?
Correct.
And you're aware that fathers filed a motion to amend the temporary parenting plan that was put in place earlier this year, correct?
Correct.
And what is that temporary plan? How often are you guys exchanging the children? For how long are you getting them?
On June 5th of 2025, we were agreed to do week on, week off. I would get the kids at 6:30 on Friday and exchange them at 6:30 the following Friday at a location halfway between home.
And whenever the week on, week off visitation began in June of this year, did all the children participate?
No, they did not.
Which child did not participate?
McKaylee refused.
Did the order cover all the children?
The order covered all 6 of our children.
So around which month this year did the week on, week off visitation start for all the children?
It started on June 6th.
Well, when did it actually start
When
being
did it actually-
exercised?
When they started coming to me for the week on, week off, McKaylee came, I believe it was around August 14th.
So why is it that McKaylee did not participate in the week on, week off visitation between June of this year and August of this year?
McKaylee and father stated that it was not court ordered, that she had to go with me.
Was father here, to the best of your recollection, whenever the court entered that order of week on, week off visitation?
Yes, father agreed to the week on, week off.
Were there any circumstances that took place that before August where you tried to exercise the week on, week off visitation with McKaylee?
Every other weekend I tried to do the week on, week off, and she refused, so I started video recording each interaction.
What do these interactions look like? Could you paint a picture for the court?
I would go to the meeting, I would get out, I'd have my phone recording, I would go to the vehicle where McKaylee would be sitting in the.
Huge moment here. The judge denies the motion to dismiss. Translation? There's enough evidence to move forward, which means someone's testimony, likely the child's, raised real concerns. This shifts the entire case dynamic and puts the mother's decisions under a microscope.
Front seat with the door locked. I would say, McKaylee, are you coming with me? And she would say, no. I said, even though it's court ordered, you're refusing to go with me. Yeah, it's court ordered. During one of those interactions, McKaylee stated, you can call the popos, I'm not scared. And Dad was in the background stating that you can send the police to my house, I don't care.
Is this the only time an interaction like this would take place, when the exchanges were supposed to happen?
No, that one happened on July 4th. The following time that it was my week with them, the same thing happened until I had to call police in Cheatham County on August 1st, since I had a signed copy for a week, every other weekend at that point, that the police had to enforce that McKaylee go with me.
So was the reason that you weren't exercising your week on, week off visitation until August because you just simply didn't want it?
No, that's not the case. It was because father and McKaylee said it's not ordered and they refused.
Did you want it?
Yes, I wanted McKaylee each and every time.
Why is that?
Because McKaylee's my daughter. I love her. I want that interaction. She's 15. I'm a mom. She's a growing young lady that needs that communication with her mom. I have always been involved in McKaylee's life. I've been there to advocate for her mental health, all of her issues. I've been there for the boy troubles that she's had.
Speaking of the medication and whatnot, do you know the last time that she's taken her medication?
I believe it was around the 1st of April. And it was around April 8th that I noticed that McKaylee was not taking her medication anymore.
And how do you feel about that?
I'm not okay with that. McKaylee has been, I'm not sure if I can list her diagnosis, but the medication that she is on is a mood disorder that's supposed to be taken daily and weaned off over the period of time.
Do you recall participating in any doctor's visits where her primary care physician or another doctor okayed her to go off of the medication when she did?
We had originally requested it back in 2022, and father agreed to it at that point to slowly wean her off. Once McKaylee was weaned off, she was back to being volatile. She was acting suicidal. So we went back to the doctor, and the doctor placed her back on medication.
When did that happen?
That would be the summer of 2022.
So whenever the child comes to spend whenever all the children come to spend their week with you, do you feed them?
Yes.
Are all the bills paid and all their needs taken care of?
Yes, they get 3 meals when they're at home with me. When they're at home with me and there's just school that day, they get dinner every night. They get multiple snacks. I don't limit access to any of the refrigerator, the snack, the pantry, or anything.
To your recollection, has the child ever brought to your attention the fact that staying with you makes her sleep schedule funky to where she doesn't get enough sleep during the week?
No, McKaylee's never addressed that with me. I try to make sure all my children are in bed between 8 and 8:30 at the latest. They do have access to watch their TVs and play on their phones if they have them, but they are laid down in their rooms and tucked in between 8 and 8:30. I go in each room, kiss each one of them goodnight. I give them a hug and tell them I love them.
So do you think that there are more rules at your house than at
Definitely
the
more
house?
rules at my house, and they have to abide them and respect each other and not be disrespected.
Can you give the court some examples of the difference in the rules at your house rather than father's house that you know about?
I can say that I make sure each one of the children respect each other instead of yelling and screaming and saying, shut up, or I hate you, or I'm going to kill myself. I make them apologize. I make them clean their rooms. They have to have their laundry picked up. They have to do their homework when it's asked of them. They have to be respectful of each other.
So do you help the children with homework and things of that nature as well?
I'm sorry, I couldn't hear you.
Do you help the children with homework and things of that nature as well?
Still couldn't hear you.
Apologies. Do you help the children with homework if they need it?
Yes, I've helped McKaylee multiple times with biology. I believe it's biology she was doing. I help all of my children with geometry or any of the math homework. It's a daily thing with each one of them. I spend one-on-one time after I get off work with them.
So since we had our first appearance on this case way back when regarding a restriction of your parenting time with the children, you recall that a big point of emphasis was Mr. Mullen being involved in your life, correct?
Correct.
Since that time, has Mr. Mullen had any contact with any of the children whatsoever?
No, he has not had contact with the children.
Do you talk to or have any communications with him in front of the children where they would know who you're talking to?
I do talk to him. The children do know now who I am speaking with. When he calls, if I'm in the vehicle, I'll put the phone off of Bluetooth and talk to him that way. Or in the beginning, when the children were coming, I would take the phone call into another room to where they weren't overhearing conversations.
And to your recollection, how many times has specifically the child we're here in court today for seen Mr. Mullen?
Prior to all of this incident, McKaylee had probably met Mr. Mullen. She came to stay with us when I moved out in November of 24. She stayed a weekend. Then McKaylee stayed Christmas Eve night. Other than that, those are the only times McKaylee's ever met Mr. Mullen.
Do you recall anything violent ever happening between you and Mr. Mullen in the presence of this particular child?
No, nothing violent ever happened. McKaylee's even went as far as to state that when there was an issue with a vehicle tire and Mr. Mullen was not yelling and cursing at me, she was like, Mom, that's different than what Dad does to you.
Did you catch that? A 15-year-old refusing court-ordered visitation while the father stands by saying he doesn't care. Judges hate when parents don't enforce orders. It signals alienation or lack of parental oversight. This moment is a major red flag and will absolutely influence the judge's final decision.
Currently, is Mr. Mullen incarcerated?
He is.
To the best of your knowledge, do you have any idea when he'd be getting out?
And he is serving a 6-year sentence, at least 85%.
So he's not getting out anytime soon, correct?
No, sir. Correct.
Whenever the children are with you during their week-on, week-off visitation, are you on the phone a lot?
I have been, yes, sir.
Are you able to take care of the needs of the children even though you may be on the phone a lot?
Yes, I would place him on hold if my children come telling me they need help with something, or if they're hungry, then I will place Mr. Mullen on hold so I can deal with my children.
Would you place anybody on a hold that you were talking to, regardless of who it was, if your children needed something?
Correct, because my children come first.
And is it your testimony to the court that you want this week-on, week-off visitation to continue with all the children?
Yes, with all of them, I would prefer the week on, week off.
And why is that?
Because I think they're getting the best of both homes. They're still being able to see their father. They're still having the structure and stability that I'm able to offer them. They're getting the help with their homework. They're happy. McKaylee comes to my house laughing and smiling. We run around playing and tickling each other. But when she gets in the presence of father and I go to hug and kiss her bye, don't touch me. Don't talk to me no more.
And to the best of your knowledge, none of the other children have ever made any comments about being in fear or being at your house, correct?
No, they have stated some things that father has said, but as children, I'm trying not to listen to everything that they're telling me. They've never given me a valid reason as to why they're in fear of my home. My doors stay locked. I work from home, so I'm home with my children when they're home. No random stranger shows up to my house. My sister's the only one that ever comes to my house.
Thank you, Ms. Forte. I'll pass the witness, Judge.
All right, Ms. Brady.
Ms. Forte, you said that you are on the phone with this person that's incarcerated when your children are present.
Yes, ma'am.
And you do know that we have an order from February from this court that said that you shall not allow any contact between the children and Mr. Mullen whatsoever, including phone contact, including no incidental contact due to the mother having contact with him in the presence of the children.
That is correct, but Mr. Mullen is not in contact with the children. He only speaks directly to me. The children do not hear his voice at all.
So if your daughter said that she hears the phone connect and hears a call is coming from Davidson County Detention Facility, that then you come off of Bluetooth at that point, do you think that's accurate?
Yes, she has heard that, in which at that time I would disconnect the Bluetooth and answer and put the phone to my ear. Mr. Mullen, it takes, I think, at least a close to 10 seconds before his voice comes on.
Okay, and when you said you're on the phone quite a bit with him, how often would you think, or how many minutes a day do you think you're on the phone with him?
It would depend on what day you're asking me.
Okay, so you said that McKaylee started coming to see you August 14th.
Correct.
And so then you would have had her from August 14th until 7 days later, maybe the 21st.
Correct.
Does that sound right? Okay. Your Honor, could I approach the witness,
You may.
please? So I've just handed you some documents that you actually have provided as part of discovery. Can you tell the court what I handed you?
It's a phone record.
And whose name is at the top of the page that we have open?
It is my nickname. It's my phone number.
Okay, so these are your phone records that you provided as this part of discovery.
Correct.
And then if we look at August the 16th, which was a Saturday, at 8:53 a.m., you have an incoming call from the detention facility. How long does that call last?
They last about 14 to 15 minutes.
Problem nowadays is late to associate that phone number with murder.
The
Okay,
same, I think you have to establish her knowledge of the phone number.
okay. What number is that from?
That number is from the detention center.
Okay, and then how long did that call last?
They last about 14 to 15 minutes.
This is where things get complicated. Mother insists she prioritizes the kids, but her phone logs show hours spent talking to an incarcerated man, the same individual the court previously restricted contact around. So here's the big question. Is it harmless, or is it exposure to emotional chaos the child is trying to avoid?
Is there a time limit that they're timed out after 15 minutes?
Yes, each phone call gets a total of 15 minutes.
And so if we look on the 16th, which would have been the first Saturday that you had McKaylee, you have 1, 2, 3, 4, 5 back-to-back 15-minute calls. Is that right?
I'd say roughly, unless I count each one of them roughly, yes, ma'am.
So from 8:53 in the morning until 11:29 in the morning, you were on the phone with Mr. Mullen.
Yes,
And that's the first Saturday you had McKaylee in your home.
that's correct.
And then if we look a little farther down, you see another set that starts at 12:53. Is that right?
I'm sorry, what was that?
At 12:53, there's another set of phone calls that start.
Yes,
And from 12:53 until 4:05 p.m., you're on the phone with him several hours. Is that right?
that is correct.
And that again is the first Saturday that you had McKaylee in your home.
If I look at the calendar, I'd have to make sure the 16th is a Saturday, but if it is, then that's correct.
Okay, and then one more, and then we're finished with this. At 8:33, it begins another round of calls that lasts until 9:42. Is that correct?
Yes,
And that's again the first Saturday that you have McKaylee in your home after all of the days that you haven't had her.
correct.
So even having not had her, you spent that much time on the phone with an incarcerated person.
That is correct. Placing him on hold when McKaylee came to tell me she needed something to the other children as well.
And this is the person that threatened to kill you and your children.
I'm sorry, that's not accurate.
So when you testified to that prior in this court, then that wasn't accurate then, and now you've changed your
The
testimony?
comment that you made about him threatening to kill my children, I stated even back then, that is not true.
Okay, did he threaten to kill you?
No, he did not.
Did you get an order of protection against him?
I did take out an order of protection that was then dropped.
Okay. So do you have any medical proof today that McKaylee is required to be on the medication that she previously was on?
Yes, ma'am. If you pull up her medical records each month, all the way up until April, I was calling them in monthly and even communicating with father to pick them up.
But you don't have anything today that shows she's still currently ordered to stay on that medication?
Yes, ma'am. Because when I took her to the doctor back last year, she was supposed to stay on that medication. I have spoke to the pediatrician who states it has not been brought to her to.
Okay, we can't talk about what other people have said, just what you have that you saw for yourself. And isn't it true that you have photos on the wall in your apartment of you and Mr. Mullen?
I don't see how that's relevant, but yes, that is true.
And you said that there was no violent activity of this man and you in front of McKaylee, correct?
That is correct.
But there was violent activity between you and Mr. Mullen in front of the other children.
That is false. That has never happened.
You didn't call Mr. Forte early one morning and say, I have to bring the children to you because of a fight that's happening right now.
No, I did not. I did call Mr. Forte the morning, I believe it was January 17th, and let him know of prior incidents that had happened when the children were not with me. And then that's where everything progressed from there.
And on these exchanges, when McKaylee denied and refused to come with you, Mr. Forte brought her to the exchange.
With every exception of the second one, I believe in June, he did bring her.
And she refused to get out of the car.
Yes, stating that it was not court ordered, and father stated it was not court ordered.
Okay. And at some point, though, when it was court ordered, she still refused to get out of the car.
It had been court ordered since June 5th. When we went to court, I just did not have a signed copy to enforce that.
I gotcha. And during these exchanges, McKaylee is yelling and crying and saying she's not going to come, and she refuses to get out of the car.
Correct. And when asked why, she would not give a valid reason as to why.
Okay. That's all I have, Your Honor. Oh, Your Honor, I would ask to admit these phone records that Ms. Forte has as an exhibit, please.
We'll mark those exhibit 1.
That's fine.
Bang.
I'm sorry, repeat that.
I would ask that not all the phone records be admitted, just the ones with the 2 pages that we actually looked at is August 16th and August 17th.
I'll allow Ms. Brady to pick out those particular records, and we'll make those the exhibit. Mr. Talley, do you have any follow-up?
Briefly. So, on your testimony, you went through some phone calls from August 16th and I believe 17th that involved you and an incarcerated individual, correct?
That is correct.
Is that what a typical Saturday looks like for you? Or
A typical Saturday, no.
And now the contradiction hits hard. Earlier testimony hinted at threats. Now she denies it. Changing stories under oath is one of the fastest ways to lose credibility in family court. Judges don't just listen to the words, they're measuring consistency. This moment could be the turning point against her.
okay.
Not when my children are with me. I should verify that.
And do you, for your job, you're on the phone a lot too, correct?
Correct.
Okay, what do you do?
I am a financial analyst.
And you being on the phone a lot whenever you're at work, does that affect your ability to parent whenever the children are home?
No.
Those are all my questions, Judge. Thank you.
No follow-up, Your Honor.
Ms. Forte, I'm new to this case somewhat, so I'm going to ask you a couple of questions. What is Mr. Mullen in prison for right now?
He is in county jail for a gun charge that he had received before meeting me.
And you said, if I understood you correctly, you said he was serving 6 years?
Yes, he got hit with a 6 years at 85%.
A 6-year sentence at 85%. So he's going to be in prison for a while. Whether he
Correct.
serves it at the county jail or serves it in prison, he's going to be serving time.
Correct.
And then the allegations that began in this case, and you said you got an order of protection against him. What did you get an order of protection against him for? Why?
There were some incidents that happened prior in December that I have never been through. I listened to a lot of people that stated I needed to go get an order of protection, so I did file an order. But as I tried to follow up and have that order served, Metro, because I live in Davidson County, they refused to come out and serve it when they told me they were going to. So the next day, I was scared and dropped it.
What did you allege he had done to you in that affidavit? A copy of that can be obtained, do you understand? And it was signed by you under oath. So I'm asking you, what did you allege that this Mullen individual did to you that would have caused you to get an order of protection? There
was an incident happened in December to where we had gotten to an argument and Mr. Mullen had shoved me and I fell into a wall.
Okay. Now, did you know he was on probation at the time, or?
He was not on probation, no.
You know he had a criminal record?
I knew of some of the things because he had prior when he was 18 years old, but he had been out for a good 8 or 9 years with no incidents.
All right. Now you know he's serving a 6-year sentence at 85%. Why are you talking to him for the majority of the day from the prison or jail?
Mr. Mullen was the person that once I left my marriage with Christopher, I had been dealing with a lot of domestic abuse that was not physical, but it was every other sense. Mr. Mullen was there to listen to me. I was able to be myself, not hide or feel like I had to be judged or be perfect like Mr. Forte had made me feel. So Mr. Mullen seen me. He listened to me as I was going through all of this. So I feel like at this point, he needs a friend to speak to as well.
Okay. If he's released from prison, are you going to renew your relationship?
With it being a 6-year sentence, I can't answer that at this moment.
Okay. Your daughter's 15.
I can't hear you.
Your daughter is 15, is that correct? And would you be okay with her dating somebody that had that kind of background and was in prison for a 6-year sentence?
Well, it depends on the charges because every person deserves a second chance. Like I stated, this charge was a gun charge that was found in a vehicle with him when he was pulled over.
Good. And you've heard the testimony, or rather you've testified that there was an instance where he made threats of some kind, whether he threatened to kill you or not. I know that's an issue in dispute. But do you understand how your daughter might not want to have contact with him?
I understand that.
And do you understand that they're aware that when you get a call from the jail, it comes in as a collect call, correct?
It doesn't come in as a prepaid call, but it does state where it's from, yes, sir.
All right. It says where it's from, and is that from the Rutherford County Jail?
He was in Davidson County. He has been moved to Rutherford County.
And when it comes in, the children, if you answer it on the Bluetooth, they know it's from a jail, right?
Correct. I tried to get it answered and have the volume cut down as I disconnect it, and then I turn the radio on for the children to hear.
All right. Thank you. Then you must step down. Mr. Talley, you have any other witnesses?
No, Your Honor.
Ms. Ray, do you have any proof?
No, Your Honor.
I'll hear an argument.
Your Honor, as we've discussed, we're not at a position where we have to prove a material change, which I think we could even if we needed to. We are just going to be looking at what is in the best interest of McKaylee. And if you look at the best interest factors, I'm just going to run through them, and I'll try not to belabor the point, but the strength and nature and the stability of the child's relationship with each parent. You heard from her and from the mother that this is a rocky relationship, and so I would submit that this preponderates in favor of the father. Past and potential future performance for parenting responsibilities. Mother can provide food, that's certain, but whether she's able to provide for the emotional stability of this child is yet to be determined. If we're looking at I think the next one that might be appropriate is number 6, the love and affection and emotional ties of each parent with the child. The emotional ties between this parent and this child are strained at best right now. If we're looking at number 7, emotional needs and developmental needs of the child, I would submit that weighs in favor of the father as he is supporting her emotional needs. The mother, on the very first day that she had this child after this extended absence, was on the phone for hours a day with the person that caused all of this to happen in the first place. And if we're looking at number 8, the moral, physical, mental, and emotional fitness of each parent, I would submit that the mother is not able to have McKaylee in the home in a responsible way, and that this favors the father. Looking at number 9, the interaction and relationships with siblings and other relatives, this is probably equal. It may favor the mother a little bit, to be honest, if she were to have the siblings in the home with McKaylee during her time. But I would submit all the other factors would outweigh that. Looking at continuity, McKaylee's been in that home for years and years. She attends school in this district, so that favors the father. If we're looking at number 12, which I think is obviously the overwhelmingly important factor, the character and behavior of other people who you might say frequent the home. It's by phone, but it is relentless and ongoing. And you heard that testimony from the child. And then also number 13, the reasonable preference of the child. She's 15. She's going to be 18 before you know it. She had articulate conversation with this court about her concerns about having to hear these phone calls and then argue with the mother about different things. And The child stated, Mom's on the phone all the time. So if she's not even effectively participating in parenting because she's on the phone with the jail, there's no reason for us to force this issue with this child.
Mr. Talley?
Thank you, Your Honor. And I would just belabor the points that I previously made to the court in this situation. Best interest of the child is obviously paramount. Mother does all the things that a parent's supposed to do, takes care of them being able to eat, has a house that they live in, make sure they get to school on time, has proper bedtimes, assists with homework, and all the things created or that have to do with that. She's able to do that, has continued to do that. Going into the best interest factors, Judge, I would assume that the ones that weren't brought up, that opposing counsel is either saying that they're even or fall to mother. However, regarding the strength and relationship of each parent, number one, we would argue that the relationship obviously is strained. However, as you've heard evidence today, that's not necessarily on behalf of mother. Seems to be that what father's job, what I would hope the court would promote, would be to help encourage that relationship to flourish in a positive manner. You heard the child say out of her mouth herself that father told her during a visit that she can go or not go. It doesn't matter to him. That doesn't sound like something that would come out of the mouth of an individual who is genuinely trying to encourage a relationship between child and parent. If going on to number two, like we said just now, mother is able to take care of the child just as well as father is. We heard evidence today about the child's medication and that there was no supervision when the child at issue stopped taking her medication. You heard evidence from mother where she indicated that she needs to be on it because it's a mental health medication, but he doesn't care about that. So I wonder why she's acting out whenever it's time to do something that she doesn't want to do, which is go to mother's house for the reason of, I'm not even sure at this point. She indicates that she's in fear of an individual who she hasn't heard the voice of. She testified that she heard that it's coming from a jail. However, I would argue to the court that that does not amount to contact in any way, shape, form, or fashion. You heard also evidence regarding her presence in the home whenever any of these interactions happened. She wasn't there. How does she know these things, Your Honor? I would argue that father is not helping the situation at all, especially as it concerns a child that probably needs to be on mental health medication and just making the situation worse. We would argue that regarding the love and affection of the child, obviously both parents love the child equally, even though they show it a little bit differently. We've heard evidence today that indicates that mom has more rules than dad does. Dad's a little more lax on these sorts of things than mother is. And I find it hard to believe that that doesn't play any part into the situation whatsoever. Of course, she's 15. She wants to do what she wants to do. Where would I go if I was 15? Where I could do wherever I wanted to do. I think number 8 falls in line with mother as well, if not equal, because as I just stated, she thinks that the child needs to be back on her medication. However, since they're doing week on, week off, she can't do it by herself. Father has to be on board too, but apparently father doesn't think she needs to be on it. And he made that decision unilaterally. And what it seems like the evidence is saying, there was no supervision from a doctor whenever they did that. Your Honor, we heard evidence today that the order that granted her this custody of split time was, I guess, it was ordered by the court in June, and it didn't start until August, and there weren't visits between that time, evidence showing because father didn't make her do it, even though he was under court order to do so. That may be contempt, that may not. I don't know, Your Honor. However, I know that this lady got on the stand today and said she loves her child. She wants to spend time with her child. And the court never makes somebody stand up in court and says that they are perfect, because he's not perfect either. But I don't think this rises to the level of a situation where the modification of the parenting plan has to take place. And that would be our argument, Your Honor. Thank you.
Well, in this court's opinion, the modification of a temporary order that's entered is quite different than the modification of a permanent order of parenting plan that's adopted by the court, parenting plan that's adopted by the court on either a temporary basis for the court to consider, or at a final hearing that the court is required to consider those statutory factors. Both of you have touched on those. Here's my finding regarding this case. You've got a 15-year-old girl who loves both her parents, but she right now thinks that your daughter thinks that it's more important for you to talk to Mr. Mullen than it is to spend time with her when she's at your house. Whether that's accurate or not, her perception is what is controlling her belief that that's how she wants to be with you. You can see whoever you want to, you can date whoever you want to, you can talk to Mr. Mullen as often as you want to. It's always kind of interesting to see women who've been physically abused or emotionally or psychologically abused who unfortunately fall back into a relationship with someone else who might be manipulative or back into that relationship with the abuser. You have an opportunity to be away from Mr. Mullen for 6 years at 85% and not to have any contact with him. He doesn't have to have any contact with your children. But your continued involvement with him has been one of the major issues that your daughter has cited as the reason why she doesn't want to come to your house every other week. She's aware when you're talking to, they're not, children at 15 are not fools. She's aware when you're talking to him. She's aware you're in communication with him. She's also aware of the fact that that he was abusive towards you. And I think that under the circumstances, this court is concerned about the example that you're setting for your 15-year-old daughter, that this is quite okay to talk to him 8 hours out of the day when she's there with you. You're on the phone with this individual while he's incarcerated. I just find that to be very disturbing. And I think that in truth, if you were to be honest about it, while you may hedge the answer you gave me about, depends on the type of cases that a person was involved in, you don't go to prison for 6 years at 85% for a slap on the wrist. You go to prison for 6 years at 85% because you've committed a serious felony that requires you to be incarcerated, and you've been given other opportunities such as probation that didn't succeed. So I'm of the opinion that the factors that are cited by both the parties in this case, there are many of them that are equal, but in this court's opinion, the preference of the 15-year-old child to how she wishes to interact with her parents is one of the more controlling ones, and the fact that there is a situation that exists in the mother's home where the mother is continuing to have contact to the knowledge of the children with the individual that has abused her in some fashions to the extent that she got an order of protection. It would be interesting to read the allegations in that order of protection because she's now testified somewhat differently to what the complaint in this case sets out as happened on that occasion. But Mr. Mullen is not a good individual to have contact with these children. He's not an appropriate individual to be around them, and the fact that you continue to have contact with him when the children are aware of that, when they're with you, is a factor that this court finds to be regrettable. And in any event, I think that it's quite understandable that your daughter does not wish to spend a week at your home. She also cites the fact that her sleep schedule is interrupted because you live in Nashville and she has an hour drive to and from school, so she has to get up at 5 o'clock rather than at 6 o'clock at her father's house. So I will grant the request to modify the visitation, but let me say this to Mr. Forte. This is going to be a court order, and that means you don't get to say, oh, well, I'm not going to force my daughter to go if she doesn't want to go. You should encourage her to go as often as she wants. Hopefully Ms. Forte is going to listen to what I've said, and that she's going to curtail her involvement with this individual. If you want to talk to him when the kids aren't there. You got a week off without him, so talk to him all day, every day if you want to, if that's your choice. But when the kids are there, it would behoove you to avoid being on the phone with somebody in prison while your children are there. But if your children are reluctant to go, I assume there are days when they're reluctant to go to school too, so they might not want to do this or that.
Yes, sir.
You're, as a father, required to enforce this court order. You don't give them a choice. You enforce the court order. I don't like to have to make these decisions, but I make them on what I think is in the best interest of your daughter. I've made this decision. You should encourage her to even go again. My biggest fear is that is going to cause problems between her and her other siblings that she's not with on a week-on, week-off basis, that she's only with them a week and then she's not with them a week. But in 3 years, your daughter is going to be able to tell you both to take a flying leap off a short cliff, if that's what she chooses to do, because she will have the right at 18 years of age to tell you that she doesn't want to see either one of you. And frankly, she could be headed in that direction if you keep this up. So you need to think about what's in the best interest of your child or children. It's not in their best interest for you to suggest to them they don't have to go if they don't want to. You should tell them, that mean old judge up there ordered that you're going, and I have to do what he says, and I don't have a choice. Don't give her a choice. The same thing is, you need to start putting your children's best interest first and foremost about things that you do, and rather than what Mr. Mullen wants or what he needs your support. And I understand you're trying to help somebody who you think has turned their life around. Well, I'm all for people having second chances. It sounds like Mr. Mullen's had more than his fair share of second chances if he got sent to prison for 6 years. But 85% means the type of crime that you commit is serious enough that they're not going to give you the standard 30% release eligibility. 85% means you serve 85% of that sentence. And that only happens when it's a very serious type of crime or one that the state legislature has specifically denoted that a person ought to have to serve the majority of. So think about that when you talk about staying in touch with him. You can stay in touch with Mr. Mullen. 6 years from now, you and he can get together. I think that would be a terrible decision on your part, and I think it will simply drive a further wedge between you and your children. But you're free to do what you want. I am going to grant the motion to modify, and that will be the order of the court. She'll go to every other weekend, and that will be coordinated with when the children go to the mother so that she's with them on those weekends. All right.
Thank you, Your Honor.
This is a temporary order, which means that it may change again at the final hearing. It's not written in stone. So when I told you, Mr. Forte, about your enforcement of that order and following the court's orders, that will be something considered by the judge as well. All right.
Thank you, Your Honor.
Thank you, Judge.